Hello and welcome to the topic on winding up of a company. This is also a topic under company law, and within our discussions, we are going to be able to understand the concept of winding up. What does it mean? We will also explore different methods of winding up a company, and we will also understand the consequences of winding up a company. Now, we begin by asking ourselves a very, very important question on what is winding up. And we are saying it is the process through which the life of a company comes to an end. So, when we are talking about winding up, we mean bringing to an end the company's activities. And when this process is taking place, it simply means that the company ceases to exist. It ceases to carry out its operations, and basically it's also struck out from the registrar of companies' records. And once winding up has also taken place, we are saying that no more operations stop. In case there were any assets, they are also sold, and the money that is received from the selling of those assets is particularly used to be able to repay any debts, if any. What is the difference between winding up and dissolution? We are noting that winding up and dissolution are not the same. Once the commencement of winding up proceedings, a company is not dissolved immediately. So once we begin winding up, we are still in the process, and therefore we cannot dissolve immediately. And we are saying on dissolution, the name of the company is struck and removed from the register of companies. And we are saying dissolution is that particular aspect or that particular final process of a company. We have different methods that can be used to wind up. And number one is what we call compulsory winding up by the court. We are going to understand what it means. And also we have what we call the voluntary winding up. And the voluntary winding up, we are going to note that it will be further classified into what we call the members voluntary winding up, and also the creditors voluntary winding up. Now, when we talk about compulsory winding up, we are saying this kind of winding up is done through a court order. That's important for you to be able to note. And the law presents, or the legal presence ends up with the company being struck out of the company's register, and then the company will thus be able to cease existing. So we are calling it compulsory because it is through the court. But of course, the court will not just wake up and wind up a company. There must be scenarios and situations that have been presented to the court and evidences that have been presented to the court. For example, a company's inability to be able to pay debt. So if the creditors are aggrieved, they can begin the process of petitioning this particular issue in the courts and presenting evidence. And then if the judges find whatever issues that have been raised are valid issues, then they can do what you are calling compulsory winding up, or they can give orders that that kind of winding up takes place. Now, what does compulsory winding up involve? If the courts give orders that you now need to stop your businesses or carrying out any transactions using that particular company that has been ordered to compulsory wind up. Number one, all company contracts come to an end. So when a court has given an order to wind up, when you're talking about company contracts, it also includes, number one, contracts or staff contracts. It will also include contracts with suppliers and any other forms of contracts that have been in place. All of them come to an end. By coming to an end, we are simply saying even them, they cease to exist, just like the company is going to cease to exist. These contracts also cannot continue to be running. The other one is any legal disputes are settled. So we might have disputes, they will be settled. The other one is a company ceases to operate. So the company will also stop its operations. And then if any assets were available, those assets are sold, and any money owed to the company is collected, and share capital is distributed to the shareholders from surplus money after paying debt. So if once we are selling the assets, one of the most crucial things that we need to do, if we had any debt, if we had not paid our creditors, if we had not paid our suppliers, part of the money that we get, we are supposed to pay them. We're supposed to pay our suppliers. And then it is what is remaining that we are saying in number 6 can now be distributed to shareholders from surplus money. Now, these are the grounds for compulsory winding up. These are the grounds that the judges will be looking at. Number 1 is a special resolution by the company. That is number 1, a special resolution by the company. So the company can resolve to stop operating. Part of the reasons would be maybe they have achieved the purpose that they set out to achieve, and through that we can hold a meeting that is going to discuss the way forward in terms of winding up. And then also default in holding statutory meetings. Remember from our discussion on the topic on meetings, we have emphasized that a statutory meeting is a very, very important meeting, and it should be held within the first 1 month of incorporation, and it should not take more than 6 months. So it is very important to understand that when you default in doing this particular meeting and it is presented as evidence in court that the meeting did not take place, then that is a situation that would contribute to the judge or the court ordering for compulsory winding up. The other one is failure to commence business. If you have been given a certificate of incorporation and you have not begun business as anticipated, then that could also be a ground for compulsory winding up. Reduction in company members, and finally is the inability to pay debts. I had mentioned that previously as we were starting. Now, we also need to know who are the people that can file a petition to wind up, because number 1, there must be specific people, and of course these petitions, I have said, they also must be accompanied by evidence. Number 1 is the company through a special resolution passed in the annual general meeting. So after an annual general meeting has been passed, now the company can be able to petition the court to give orders for winding up. The other one is another group that can be able to file a petition is the creditors. They should be able to prove that the company was unable to pay their debt, or if it's a creditor, his or her debt. And finally is the registrar of companies. And maybe reason number one is maybe you have not held your statutory meeting, and you have also maybe gone against the object clause. Remember when we talked about the contents of the memorandum of association, we talked about the object clause, and we said the purpose of this particular clause is to be able to state the reason as to why you exist as a company. Now, if the registrar's office realizes that you have gone beyond powers, beyond what you have stated in the object clause, that is also what we refer to as a doctrine of ultra vires. So you have gone against the stated objectives of the company. Then the registrar can also petition the courts to be able to request for the winding up of that particular company. So if they want to present anything, including what I've just said about acting beyond your stated objectives, then they need to have evidence and proof that you have really done this as a company. Now, the registrar has grounds also to be able to file a petition. Number one is failure to hold a statutory meeting or to file a statutory report. Remember, we have emphasized on the issue of this statutory meeting and its importance. It's very, very important. And of course, once you hold the statutory meeting now, you are required to present a report to the registrar. So if this report is not there, it could be a ground for the registrar to say they have not received a report, and therefore that can also lead to them concluding that the statutory meeting did not take place. And also the other one is failure to commence business within 1 year of incorporation. So the company law has its restrictions in terms of once you've been given a certificate of incorporation. This is like the birth of that particular company. Then you are expected to have to begin your business within that stipulated duration of 1 year. So if you do not do or commence business within that duration, then you are deemed to be in trouble that would cause maybe the registrar of companies to seek or to petition for the winding up of that particular company. Another ground that the registrar may use is when membership falls below the statutory limit. Membership of a company. Remember, we have different statutory limits for private limited companies, for public limited companies. So when you are below the stipulated numbers, then the registrar can be able to use that as a ground to file a petition. And finally is another reason that the registrar may file a petition is if the company is unable to pay its debts. Now, commencement of winding up. And we are saying the process of winding up is presumed to have started on the date when the petition was filed. That's very, very important to note. Yeah. The moment that those papers were presented to the court, the moment the petition was filed, that is presumed to be When we talk about presumed, that is assumed to be the date in which the process of winding up started. And we are saying in case of special resolutions for winding up is passed before the petition is filed, winding up is deemed to have started when the resolution was passed. Sometimes we may not have presented the petition, but we held a special resolution meeting that began discussing the aspect of winding up. So we are saying in that particular scenario, winding up will be deemed to have started on that day that we began or that we held the statutory meeting. So that means even if we start with the statutory meeting and then we go to the next step, we will still deem the day of this special resolution as the day that the process of winding up that particular company started. Now, the court, like I've said, it's not just an institution where we walk in and our expectations are met. That's why we are looking at, or we intend to discuss court powers on hearing the petition. What is it that the court can be able to do? Yes, they have been presented with these grounds, like the ones that we have seen by the registrar. These grounds that are right here. Failure to hold a statutory meeting, failure to commence business. Now we want to know what is the court supposed to do? And we are saying the court may, number one, dismiss it or with or without costs. So the petition may be dismissed. With cost means certain parties, those that have filed the petition, might be ordered by the court to pay the company some money. The other one is hearing may unconditionally be adjourned. So that's another option that the court may have, or another thing that the court may do. The hearing may unconditionally be adjourned, so or unconditionally be stopped. And then the court can also issue an interim order, may be made if the court fits thinks that it is fit to give an interim order. An interim order is maybe a temporary stop of the court proceedings, and then finally is make an order for winding up. So if they are not able to give the three, they can also make an order to wind up. Now we have what we call the consequences of winding up. What is likely to happen? Number one, the registrar must have received a signed copy of the petitioner and the company within 30 days of the order. So once the court gives an order to wind up, it is the expectations of the court, or they are expected to submit a copy of the judgment or the ruling to the office of the registrar and also to the company, and within 30 days. That one is very well specified on when it should happen. Another consequence is that no any other legal proceeding against the company may be commenced. If already the company has been ordered to wind up, then no more legal proceedings or legal cases may arise because the judgment has already been made. The other one is the official liquidator takes over and the board powers end. So we have the liquidator taking over. This is the person who will be in charge of ensuring the winding up process is complete. And then also another consequence of winding up is that all debts become payable immediately. So all debts that were unpaid, they become payable immediately. And that's why we said, we emphasized on the issue of, if we get to this point, then we now begin to sell our company assets so that we can be able to pay any debts. And finally is that the liquidator has a custody of all property. Now, the other method of winding up is what we call voluntary winding up. And we are saying this kind of winding up is done without the intervention of the court. So the court is not involved in this kind of winding up. And it can be done by members or by creditors. What are some of the circumstances that would contribute to voluntary winding up? Number one is by passing an ordinary resolution. And this resolution will be expired duration of the company. Maybe we had set out to carry out certain activities within 1 year, 2 years, and that duration has elapsed. That could be a situation that would lead the company members or the shareholders to voluntarily bring to an end the activities of the company. And the other one is the articles provision of winding up in case of an event. Maybe in case of a certain event has taken place. We are unable to pay our debts and so many other events like we have been discussing. That would trigger us to do what we call voluntary winding up. And the other one is by passing a special resolution that the company be wound up. So there can be a special meeting that is going to have members agree to wind up. Members voluntary winding up, we are saying can only happen when a company is solvent and are able to pay all the debts. So as members are agreeing to voluntarily wind up, they need also to have capacity to pay all the debts. And if they do not have capacity, the first thing is to be able to sell the assets of the company, so that the proceeds that are gotten from the sale of those assets can be used to pay debts. And another observation in this particular discussion on members voluntary winding up, we are saying company should declare it has no debt, or that it has the ability to pay all debts in full. So you can declare that you do not have debt, and if there is any debt, then you need to show the proof or the ability to be able to repay all those particular debts. And finally, we have what we call the creditor's way of winding up. This happens when the company is not in a position to pay its debt in full. So we may have companies that will find themselves in that kind of a situation. They are unable to pay their debts in full. We are saying with creditors having an interest in such a matter, they have powers to supervise and control the winding up. So if the company is unable to pay the debt in full, that puts creditors in a sole position to be able to dictate how this winding up is going to take place. And therefore, it is important to be able to understand these ways of winding up so that we stick to company law, we stick to what law expects us to be able to conduct this particular process. Remember, like you are saying in this particular slide, you cannot just wake up and wind up. If there are debts that are unpaid, it means you have to do everything possible to ensure that you pay those debts, so that now we can now begin to completely now exit the market. So that last slide brings us to the end of the discussion. Kindly do research on these different types of winding up and understand how they are done, how they take place, and that will be able now to broaden your mind more from the discussion that we have just had here.